All right, this is the sort of the first episode of the ABCs of debt collection defense. And it really is about two words: control and tone. Control and tone. Less control is with the court. You don't want to be there because the court rules, and you want to keep it in the initial stage of when you first get that lawsuit. So you get the lawsuit. It's not a happy time, of course. And the plaintiff has filed the lawsuit. You are the defendant. So it's usually a triangle. And when you get that lawsuit the first day, have your pity party, be upset, and then we've got to go to work. And so you're getting the lawsuit, and the rebound is you. In this space here, you generally have 20 to 30 days to respond to a lawsuit. All right? So if we key on the 20, which is Florida, 30 or 28 is Michigan, and everything else in between, and extensions and everything else. But what you want to do is set the tone. What do I mean by that? You're on your heels with a lawsuit. They're coming at you, right? We've talked about sparring and punching and getting them on their heels in my other videos. So between the first day you receive the lawsuit and let's say artificially you set the date at the 15th, engage the plaintiff. Engage the plaintiff with settlement discussions. Two things. Never talk to the plaintiff or the debt collector attorney or the headset Harriet without saying this is done for the purposes of settlement. I don't admit to anything, but I'd like to cut my costs and offer you nuisance value. Offer nuisance value so I don't have to put the time and money into hiring an attorney maybe or doing all the work that's required. That's why you're coming to this site for the membership research. And your 15th day, let's say you were served March 1st, and March 15th is your dead nuts solid day. You have no respect from the debt collector. They don't like you, you owe a bunch of money, and you have no excuse. So you engage them in settlement discussions, but each time you tell them, the 15th I file my answer if we aren't able to work this out. Second, they will get you to admit something. They'll almost give it a sort of an invitation fee. They'll say, look, if you just tell us, did you run up the card? What happened? Tell us what happened. And just like if a cop pulls you over, you don't admit anything. Cop pulls you over. He says, you know how fast you're going? You say, no. You know you were speeding, right? I don't know that. Don't admit anything, because that's the beginning of the end. Any admission you make to them will hurt you in the future as the litigation goes on. They need to have you say you admit to something. Don't. Every discussion, I just want to let you know, this is only being done for the purposes of settlement. If they won't agree to that, get out of Dodge. But you keep relying, you keep saying, on the 15th, I'm going to file an answer. If it gets to the 15th, between the 13th day and the 15th, you settle most of the cases at this stage because maybe they're going to start taking you seriously. They don't, but if they don't settle the way you want to settle, and you've got to be reasonable, they've got to be reasonable, file your answer on the 15th. Do not make threats to do something and then don't follow it up. But if you file the answer, you serve it on the court, you serve it on them, keep a couple of timestamp copies for yourself. you have gotten out of this funk here where you're having a pity party. Now you've made the opportunity to settle stronger. So between when you file the answer and you serve the answer to the lawsuit on the court, again, you have less control when you involve the court. But at these preliminary stages, the court's really not screwing around or getting in your way. They're just going to automatically kick out what's called a pre-trial notice. Let's go blue so you can differentiate. A pre-trial notice. And that's where the parties of both sides, whether it's the attorneys or the attorney and the self-represented client, come before the court for the first time, usually in a Zoom, and they'll want to put you in a room to try to settle the case before the pretrial. Accept that. Between the 15th day and the day of the pretrial is a right time to settle the case. You just set the tone setter. The answer is a tone setter, that you stick to your guns and you hit him with the answer. You may also want to hit him with a counterclaim if you have the basis of a good one, a good faith basis. So that feeling that you had when you first got that lawsuit, they get that feeling now. And they take you seriously because they now have to report. They have a duty now to report back to their client that a counterclaim was filed. That's not a happy conversation because the debt collector, the guy that owns the debt wants to know they went in, they won it, they got a default. The whole modus operandi of a debt collection company, their number one goal is, let's go blue, go blue, is the default. 80 to 9% to 90% of all cases end in a default or a bad settlement for the defendant being sued. So instead, they're reporting back that you filed a counterclaim against them. Now they're on the hook. There's actually legal things that they have to do now and spend more money. So that stage between the 15th day and the pretrial is ripe for settlement. Okay, so we're going to get into the next stage, talking about the answer, the counterclaim, but most importantly, the counter affidavit. This is your whole case right there. Everything's about the counter affidavit. We're not getting into that right now. This is the first stage of the ABCs of debt collection defense. But between the initial lawsuit and when you set the tone and now you're going to the pretrial again is where the court sets the litigation dates. When is discovery over? When is your exhibit list due? When is your witness list due? And they'll send you all this information and you just put it into your computer. When is the summary disposition date? All that stuff is down the road. I'm talking to you today to get you in shape and ready for the next stage in my video, which is the counter affidavit, the answer, and the counterclaim. That'll be in the next episode of the ABCs of debt collection defense. In this stage, I have already done several videos. I am offering the ABCs of debt collection defense in a giant bundle on my Collection Stopper membership website. And it is going to be chock full of all these videos that I've done at every stage. This is a schematic taking you through from the lawsuit to the end, which is a trial, if he gets that far. Good cases don't get to trial. So let's see what happens if you get beyond the summary disposition. But this is the first stage of 4 videos that I'm going to do. So I'm going to do the discovery, the answer stage. Then I'm going to do the discovery stage. Then the fourth video of the bundle will be summary disposition, trial. And to wrap this up from this stage that we're in, at every stage you can settle the case. Your strongest opportunity is here and here. However, if you do a good job in discovery, they'll not want to answer discovery. They'll suddenly start talking settlement. And you may get money from them if your counterclaim is solid. So that's it. That's the first video of 4 that I'm going to do for the ABCs of debt collection. Each video quadrant will be including other videos I've done. So this first, let's say, quadrant is going to include a video on how to settle a debt, how to talk to the debt collection attorney, things like that. That'll offer you great insight if you choose to go that way. But there will be 4 stages of this ABCs of debt collection defense at my site, collectionstoppermembership.com. So I'll close now. We want to keep everything away from the court as much as we can, because the longer this case goes on, this court gets involved. You do not want the court involved because generally they're biased against you, generally. There will be a video on why courts do what they do. I will include that along with this ABCs of debt collection defense. I'm going to throw that. Why do courts do what they do? But I'm also going to give you, as I talk, this gets better for you. Your first court appearance. What do I do? First court appearance. Well, what you do is dependent on what state you're in, but I will give you a video of the best ways to handle your first court appearance. You'll love it. So all these videos, there's several of them, will be included in the ABCs of debt collection defense. This is a mess. So I kind of wrote down what I'm verbally telling you, what the videos will show you, which paperwork will incorporate all this information. And let's get to it. Thank you.